Great, thank you. Good morning, everyone. This is the May 24th, 2018 regular meeting of the Washington State Public Disclosure Commission. I'm Commissioner Chair Ann Levinson, joined today by Commissioner Jack Johnson, Commissioner David Ammons, and on the line, Commissioner Downing.
Good morning. I am here in Seattle, heading to the airport midday, so I appreciate being allowed to appear in this forum.
Great, thank you, Commissioner. And please just, whenever you want to weigh in, just shout out so we don't miss that.
You've never looked better, Bill.
Thanks.
Do we need a motion?
I'll raise my hand.
Yeah, there
I'll
you
raise
go.
my hand for attention.
Let me ask the staff, Chad, I'll start with you, if you all would introduce yourselves for the record.
Chad Stanford, Assistant Attorney General for the PDC staff.
Beachy Sandal, Deputy.
Kim Bradford, Communications and Outreach.
Peter LaValle, Executive Director.
John Meeder, Assistant Attorney General for the Commission.
Great, thank you all. And fortunately, or unfortunately, depending on your perspective, because we've already had two special meetings this month, this meeting can be a little briefer today. So let's start with public comment. And Mr. Edwards, please come on up.
Chair Levinson, members of the Commission, thank you for letting me testify today. I submitted some written testimony that I'd like everyone to review once you get the chance. I'm not going to say too much more that I didn't already cover in the written testimony, other than to sort of explain my belief that the PDC's enforcement process is becoming sort of a big black hole that's becoming unmanageable from my perspective as a member of the public, and I think a lot of other people share the same view. Someone submits a complaint. It goes into the process, it sits there for months or more usually years. There doesn't appear to be any real, momentum on clearing the backlog. The former citizen action process was a tool that people could have used in the past to resolve these issues, get them in front of a judge. Some people, I think, thought that was too draconian, and yeah, maybe you're right. But it was a great relief valve, and now it appears that that's going away with these emergency rules as drafted. They allow the PDC to claim to have held an initial hearing, which, based on the rules that I have seen, doesn't actually guarantee any real momentum on the case and doesn't really require that the case be adjudicated or that a fine be issued. And for me, that's problematic because I see the backlog. I think the backlog will just keep getting worse and worse and worse. And I don't think that really does justice to the PDC's responsibility to enforce 4217A or WAC 390. So I would like to see a little bit more time and effort go into looking at the draft emergency rules, which I don't think have to be adopted immediately. I talked a little bit about that. But, I think the initial hearing needs to be, the requirements for what an initial hearing constitutes should be increased. And I think in an ideal world, I think there's no real reason that a complaint shouldn't be adjudicated within 90 days or alternatively referred to the Attorney General's office if it is more complex. So I'll just leave it at that. So thanks for having me.
Thank you. Any questions? All right, we'll take this. Thank you. Appreciate that. All right, we'll be talking more about this in the rulemaking discussion in a little bit, so we'll come back to this. Let's move to, we have three sets of minutes. The regular meeting minutes from April 26th and the special meeting minutes from May 9th and May 17th. And for the record, just for my colleagues, I did ask the staff to make one additional edit to the April 26th meeting minutes. So just want you to know that, which is that we were noting for the stipulation that the respondent was now in compliance with the exception of the electronic filing requirement. So that I had just not as clearly written that as clearly as it should have been. So it would change from the phrase with the electronic filing exception as noted to the phrase with the exception of the electronic filing requirement, comma, as noted. Okay, are there any other proposed amendments, or is there a motion for the minutes?
Move we approve the minutes for the April 26th regular meeting with the update by the chair.
Second.
It's It's been moved and seconded that we approve the April 26, 2018 regular meeting minutes as amended. All those in favor, please indicate by saying aye.
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 Great, thank you. That motion carries. And then the May 9th special meeting minutes.
Move we approve the May 9th special meeting minutes.
Second.
Been moved and seconded. Any further discussion on those? Okay, all those in favor, please indicate by saying aye.
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 Commissioner Johnson? Were you in?
Aye.
Yeah, okay, thank
Sorry.
you. All right, and then lastly, the special meeting minutes of May 17th, 2018.
Chair, I don't think you indicated whether it was.
Thank you.
passed.
That was approved unanimously as well, the May 9th, adoption of the May 9th special meeting minutes. Thank you. And the May 17th special meeting minutes.
I'll move approval of the May 17th minutes.
Is there a second?
Second.
All right, any further discussion on those? Hearing none, all those in favor, please indicate by saying aye.
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 All right, the May 17th special meeting minutes are adopted. Thank you all. Okay, let's move to item 3 on the agenda, reporting modification requests. We have a new request and a renewal with a change. And I'll ask Ms. Hanson to introduce herself for the record.
Thank you very much. My name is Jennifer Hansen. I will be presenting the requests for modifications today at the regular meeting. Both applicants have identified their request in the cover letter and the other meeting materials that were provided to the commission.
Let me just really quickly, do you swear or affirm under penalty of perjury the information you'll be providing this morning will be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you. Please go ahead.
The first request is a new one. It is from Senator Kevin Ranker. Senator Ranker is requesting a modification that would exempt him from disclosing the business customers of a entity that he owns and serves as CEO. The entity is called Global Mindset Strategies Group. His request is to not disclose the business customers, of which he has identified there is one during the reporting period of 2017. Senator Ranker does have 100% ownership of interest in Global Mindset Strategies Group. He is aware of the clients and is requesting to not disclose the one client because it would cause a competitive disadvantage. He has indicated that he would agree to recuse himself if there was a matter that came before him involving Global Mindset Strategies Group. In addition, he has confirmed that Global Mindset Strategies Group received no payments from the state of Washington during 2017.
Questions for staff? All right.
I'll move that the commission grant the partial reporting modification as requested on the basis that literal application of the law would cause manifestly unreasonable hardship for the applicant and that a limited modification would not frustrate the purposes of the act.
Second the motion.
Okay, been moved by Commissioner Johnson, seconded by Commissioner Ammons, that the modification request be granted. Is there further discussion? All right, all those in favor, please indicate by saying aye.
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 All right, that motion passes unanimously. The next request is a renewal with a change.
Yes, the next request is a renewal with change made by Jenny Durkin. Jenny Durkin is the current mayor of Seattle. The reason her request is being presented to the full commission is last year when Ms. Durkin was a candidate for office, she requested a modification that included her residential address not being disclosed, as well as the clients of the law firm that she was a partner in. This request this year does not include residential address. The commission was given some additional materials that were provided by the applicant, Mayor Durkin, regarding some very specific details about her residence. Staff requested that Ms. Durkin identify whether the property was sold during the last reporting period and therefore was not an oversight by the applicant to not request a modification renewal for her residence, but rather was not necessary anymore. The applicant indicated that the property was indeed sold. That is confirmed by her F1 that was filed this year, as well as the lack of information and request for renewal for that portion in her modification request this year. She is requesting a renewal of a modification request that was received last year regarding the clients of her law firm. Ms. Durkin left the law firm of Quinn, Emanuel, Urquhart, Sullivan, and Sullivan LLP last year. She took an unpaid leave of absence and then was officially separated from the law firm in November, late November 2017. She's requesting a modification that would apply to that last portion of 2017 where she would have otherwise been required to disclose all of the clients or request and be granted a modification to not do so. She has now left the law firm and will potentially not need this request again until she's no longer an elected official. So that is the change that was noted in the cover sheet.
Thank you. And just as a reminder to commissioners, when her request for modification came up previously as a candidate, we had indicated that if she still maintains a personal residence, if she were to be elected as mayor, then that would have to come back. The consideration would be different for someone as mayor than it was in that prior role as the U.S. attorney. Folks had a chance to review this, and is there a motion or any questions for staff?
No, this is relatively straightforward compared to the slightly more complicated one that you described for last year. So I move the commission grant the partial reporting modification as requested on the basis that literal application of the law would cause a manifestly unreasonable hardship for the applicant and that a limited modification would not frustrate the purposes of the act.
Is there a second?
Seconds.
All right, it's been moved by Commissioner Johnson, second by Commissioner Downing, that the commission approve this modification request. Any further discussion?
I have a question. Does that motion include both elements of the law firm and the non-reporting of residence?
There is not a request before us on the residence because of the additional information she provided that at this time she doesn't own a residence.
So she doesn't need a modification on that point.
Other questions? All right. All those in favor, please indicate by saying aye.
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 Any opposed? All right, that motion carries unanimously as well. So those two reporting modification requests have been approved. There are several others that will be handled later this afternoon in a single presiding officer hearing.
That is correct. Those are ones that are eligible to be heard at a single commission, single presiding officer hearing. I did want to clarify for the record, if Ms. Durkin would like a modification for any reason in the future, would the commission want that to come back to the full commission automatically, or would you like to take it on a case-by-case basis? She could potentially, it looks like from her communication with staff, request a modification in the future for either residence or law firm. I would imagine it would depend on her current status.
Well, my perspective is the law firm one has now been heard by the full commission, so that could go to a single presiding officer if that were to come up again, but the residence has not yet been heard by the full commission in this elected official capacity, so it would need to come back.
Thank you very much for the clarification.
All right, thank you. Next item is agenda item 4 is an Administrative Procedure Act petition to amend WAC 390-18050, and Executive Director LaValle will be presenting this.
Thank you, Madam Chair. You have before you a petition for rulemaking. Any person under our WAC 390-12-255, any person may request that the commission engage in rulemaking, and when the agency receives such a petition, pursuant to the Administrative Procedures Act, RCW 3405-330. The commission must, within 60 days, either deny the request in writing, specifically addressing the concerns that were raised by the petitioner. The commission could alternatively deny but explain alternative means to address the concerns raised by the petitioner, or the commission could move forward with the normal rulemaking process. In this case, we have the commission has approved emergency rules in light of House Bill 2938, and is set to move forward with a permanent rulemaking process. So the commission would probably want to take into consideration the fact that that process will be going forward, covering similar subject matter that would potentially address or have the opportunity to address the concerns raised through the public comment period and the commission's own deliberations. And with that, if the chair would like, I can answer any questions, or we could invite the petitioner to discuss the proposal.
We do have already on the table for the permanent rule, getting additional stakeholder feedback on the commercial advertiser rule 050. We had talked during the emergency rulemaking process about enhancing, if you will, the obligation of commercial advertisers to provide those records electronically, and to get some additional stakeholder feedback on that as part of the permanent rulemaking. There are a couple other elements to this request as well. So if it's all right with my colleagues, I'd like to have the petitioner come up and just do a quick summary of the key points you'd like us to be aware of.
All right, thank you again. I'm going to try not to read through this entire thing again, but touch on 2 points I think that the emergency rule did not cover that was adopted earlier this month. And I thought the emergency rule was a great thing. I thought it was a big step in the right direction, but there are 2 specific areas that I think it's deficient. And the first area, and I think the most important area, is determining whether or not someone who is requesting to view commercial books of account is allowed to take notes, is allowed to take pictures during the inspection process. And that's something that, to my knowledge, PDC staff have told people wishing to view books in general, not only in this instance, but also when viewing candidate books of account, no, you cannot take pictures. And I think that that is not consistent with the statute. It's not consistent with the liberal application of the law required of RCW 4217A. So I would like to see some sort of official interpretation or some sort of statement from the commission letting people know that it is or isn't okay to take pictures. And if it isn't, I'd like to see some sort of a response as why the commission thinks that that is not acceptable. The second, but also equally, I guess, important here is what materials someone can view when they are going to, let's say, Facebook. What does Facebook have to provide to the person wishing to view the commercial books account? And again, big step forward with the emergency rule, allowing people to view the number of impressions that have been made and the rough geographic location of where the targets were made. But increasingly, it's not just geo-targeting anymore. It's not just targeting people based on political preference. It's custom audience targeting, and I don't know how many people here know what that is. There are a lot of people in the consultancy world that still don't know what that is, but that is when you take a list of people, let's say voters, you have as many fields as possible to link them up with a Facebook profile or a social media profile. You have first name, you have last name, you have address, you have city, you have zip code, and you can actually put an ad out to that person for a very cheap cost, sometimes as low as a penny or two, and you can target a specific group of people. And that's what we've seen that some of the Russians are to have done during the 2016 election. And we still don't know how exactly they got that list, who they got it from. In many cases, we see candidates using these lists, but we don't know where they got it from, raising the issue of undisclosed in-kind contributions and things of that nature. And so I think it's important that the list of things to be disclosed be expanded, and I think that that is consistent with the statute, and that is consistent with other rules, I should say the same rule that the PDC has adopted as it pertains to mailing houses. It requires disclosure of mailing lists, directory services, and things of that nature. So I don't think it's beyond the statutory purview. But other than that, I would just urge adoption of this rule either at, I don't think you can do it at this meeting, but as you move forward with the permanent rulemaking process, if this could be something that you consider, I'd appreciate that.
Absolutely. So just on the latter point, in terms of the word use of the word lists, is there a different way to describe what you're intending by way of info, so there's clarity of information?
Well, the list, ideally, you know, what I would like to see is with these disclosures that they be made digitally. And I think we're moving towards that. But I would like for a person to be able to get the actual list submitted by the person taking out the ad. I think that all the information and preferences communicated by the person purchasing the ad be available for public disclosure. And I think that that would really improve transparency of how these ads are being targeted, which is more and more and more important. So,
Thank you.
thank you.
All right, questions, discussion?
Well, I guess I have a procedural question under the APA. The options of the commission are either to deny it and explain how we're going to address the concerns and the alternative means, which is in play in the fact that we've got these rules that we're proposing to be revised in the fall. But option B for us is initiate rulemaking proceedings, which we're sort of doing already. So I'm not sure denial is necessary in view of the fact that we've got rulemaking proceedings underway. There are some points in this proposal that are worth considering as we move toward that. I guess I don't feel like we need to deny the petition because we are in fact grinding those wheels right now.
Right. My perspective on it would be that we, in fact, would be granting the request to initiate rulemaking because we are conducting a rulemaking on this, and that this could be presented as stakeholder input into that permanent rulemaking. So it wouldn't require and I'll ask counsel, it wouldn't require a parallel rulemaking, but the fact that we have a rulemaking that will be permanent rulemaking for 030 would allow this to be subsumed into that. Is that?
I would agree. Since you have, I mean, there are new things in this particular
Right.
rule, so since you already are moving forward with reviewing this rule, I think you can accept it for rulemaking and add it to your existing process.
Madam Chair, what keeps this from being its own thing? It says that the motion that the commission initiate rulemaking proceedings regarding the material that's been submitted. I mean, I like the idea of doing it simultaneously, but is there, I don't know the APA well enough to know why that motion would not create a fresh parallel track.
I think that today your decision is whether to initiate rulemaking or not. So once you initiate rulemaking, the commission has the authority to combine it with other rules, to review it later, to do pretty much whatever you would normally do with a rules process. You're just agreeing that this information is worth review. And so once you accept it, then you can combine it with your existing process. You can create a second process, whatever you all choose to do. So I don't have any legal barriers in my view to you, assuming that once you initiate the process that you'll combine it with your existing process. I don't think that the APA contemplated every time one of these happens, you have to start CR 101 over again for each change that you decide to accept.
So do we have the proper motion in front of us then?
I think the
top one?
There's a very basic motion, if that's the commission's choice, is yes, simply to initiate rulemaking for this particular rule, and then you have your regular rulemaking authority from that point forward to do what you think is appropriate. The petitioner still has rights of appeal under the basic rulemaking process, so this isn't the end of his involvement either. But there's a due process, there's all the recourses available under the permanent rulemaking process. You're just deciding today to add this to that discussion.
So the fact that we previously voted to initiate rulemaking on a permanent basis for this particular WAC rule.
But not with these particular
This
changes.
does not duplicate or fuzz that vote.
I don't think so. If you feel like it has more clarity to deny it and articulate an alternative, which is that's the same result. Essentially, you can certainly do that also. The denial needs to be in writing with those reasons, and we could put something together for you if that's the commission's. take as well.
I'll make a motion that we initiate rulemaking of WAC 390-18050, and that both in response to this petition, but also on the commission's own initiative, and that those be combined together into one process.
Second the motion.
Since we've already initiated the permanent, both emergency and parallel permanent rulemaking, I'm wondering, and just consider
Sure.
it friendly, does it work if we say, move that the commission initiate rulemaking proceedings for the proposed rule changes in accordance with RCW 3405-320 by incorporating these suggestions into the previously initiated rulemaking process? Is that?
That's fine. That's certainly consistent with what I had in mind.
Okay.
I think that's just fine.
I just want to be clear what we're doing.
You can modify
here.
the motion for clarity. I think that's a good thing. It's no problem.
So I'll accept the chair's restatement of my motion.
And my second follows that.
All right. So it's been moved and seconded that we initiate rulemaking proceedings for the proposed rule changes in accordance with RCW 3405-320 by incorporating these suggestions into the previously initiated rulemaking process.
Can I raise a brief comment, Madam
Yes.
Chair? Just wanted to clarify, you're not choosing to adopt the suggested changes wholesale. You're just considering the suggestions as part of your rulemaking process.
Yes, as with the other, and to be crystal clear, as with the, we have a number of other things that during the emergency rulemaking, we did not put in the emergency rule, and we said we wanted to consider during the permanent rulemaking process. So my view is that these would be additional inputs to be considered during the permanent rulemaking process on this section of the WAC. So no decision is being made as to whether to accept or reject, but to initiate the process by which we'll get additional input. Is that?
I have another question.
Sure.
This is my first trip through the APA vineyard. Does Mr. Edwards have any particular standing as we go forward and looking at this section?
He has the same standing as everyone else. There's no indication that his comments are more or less weighty, even on his own changes. He obviously has the information, he has arguments that he's researched, so in that sense, he may have more information. But once the permanent rulemaking process includes these changes, then just like any other member of the public, he can comment or not.
The effect of the petition is to get a ball rolling,
Right.
not to
Right.
control the substance of the outcome.
Right, and even if the petitioner were later to say, I want to withdraw, the commission can say, we're going to keep it in place, because the ultimate control of the rule remains with the commission and not with the petition.
Let me ask, Peter and Kim, part of what we were envisioning would be happening as we develop the permanent rule is there be stakeholder outreach on various ideas that had been put on the table for consideration in the permanent rule. So the requirement of digital access, we had some discussion at the last meeting about the standards of review versus reconsideration, things like that. They just weren't either right for emergency rule or needed addition. So these ideas would go in that bucket, if you will, out for more stakeholder input and consideration. Are you envisioning it the same way I'm envisioning?
Yeah, I certainly am. And for instance, just to clarify, one thing Mr. Edwards said is that I believe our guidance does not say that you cannot take pictures of materials. It says that you, as the person whose books are being reviewed, does not have to allow that, which is, I think, a distinction that does have a difference. It's not saying that you cannot allow that, but you do not need to allow that. But I think that's a good example of something that I'd love to hear from all viewpoints of the community filers and interested parties, what they feel about that, and maybe that makes things easier for people.
And so part of it, and I think we'll probably maybe talk more about this in a little while also, but how you get that, how you highlight for stakeholders, here are a couple different perspectives on a change to the WAC. We want your input on these, as opposed to just sending out the rule and saying, figure it out yourself what's different about, right? And so, you know, there's some meaty differences that might come through in the permanent rule, and we want to draw people's attention to that and get the diversity of perspectives from our stakeholders.
Absolutely.
All right, Commissioner Downing, did you have any question or anything you wanted to add on this?
Thanks. Yeah, I would long distance if I could toss something in. First of all, I agree completely with the procedural discussions that have gone on. I wanted to make one substantive comment just because it was on my mind and maybe something for Mr. Edwards and all of us to think about further. When we talk about the preferences and the targeting, it seems to me there may be a line that's drawn between the preference and targeting of the candidate and committee on the one hand, and then the separate question of the proprietary methodology or whatnot of the advertiser themselves. And I think that it may be that ultimately a distinction needs to be drawn between those two things. When we talk about stakeholder input, I suspect that's something that we would hear from the advertising community, that they felt they had a proprietary interest in some aspects of this, and that would be something that we may well want to acknowledge and recognize. As far as the photography is concerned, you know, we always had this in the courthouse where I was the bench bar press liaison for many years. There were some courts and clerks that took the position that the public and the press during recesses and proceedings could look at the admitted exhibits, but they could not photograph them. I always took the view that had no real sense to it, and I would incline at this point, although I'll listen to arguments to the other side, but I would incline to the view that photography is a good idea and it should be permitted.
Thank you. So for further clarity, just bear with me a second. Would it be helpful for folks if I amended my phrasing to say, by incorporating these suggestions into the stakeholder review process for the previously initiated rulemaking? So that.
It's clear.
Okay. All right. So it's been moved that the Commission initiate rulemaking proceedings for the proposed rule changes in accordance with RCW 3405320 by incorporating these suggestions into the stakeholder review process for the previously initiated rulemaking. All those in favor, please indicate by saying aye.
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 Okay, that motion carries unanimously. So thank you. We will include these in the ongoing process now. Really appreciate the suggestions. Okay. So next up is agenda item 5, and that is an enforcement and compliance update, and we'll have Mr. Young present that, and we are ahead of schedule, so we'll pause for a second to give him a chance to get in.
Great. I'm sure Kim just went to summon him, so he'll be right with us.
Madam Chair?
Yes.
While we have a little pause in the action, what we just dealt with reminds me that we were looking for a discrete list of stuff that we put off into the bucket called, we're going to consider this for the permanent adoption. And I have not received that yet. Wonder, I did get BG's sort of omnibus legislation but it wasn't what I was looking for. I think we need to, so all the stuff that we parked I would love to see all of that sort of by section.
So we had an opportunity to talk about this a little bit, and what we are looking for is just a simple Word document that has, here are the items that in the special meeting process, the commission determined were not ready for emergency rule, but might be, we would want to consider for the permanent rule and get some stakeholder input. And here were some where there was discussion of just that it's not emergency rule appropriate, not that it necessarily was going to make it into the permanent rule, but it didn't fit under the umbrella. So we'll get that list back from staff and council and a schedule, clarity on the schedule. We'll talk more about that in the rulemaking as to when that will come to us, and then when the draft of the permanent rule will come to us, and then what the stakeholder outreach will be on some of those critical items to make sure that we're highlighting for folks what they might want to weigh in on. Right? Is that fair? Okay, so we'll come back to that a little bit when we do rulemaking. Morning.
Thank you, Madam Chair. Kurt Young, Compliance Officer with the PDC. This is the complaint status update memo from April 23rd through May 22nd. It's also been provided a spreadsheet that's part of your meeting materials of all the open cases. So the summary was as of, that should say May 22nd, we have 429 cases that are open. During the period, we opened 31 new cases. Closed 31 cases, opened 38 new cases. Cases that were closed for no technical violations or minor filing errors and complaint return letters. Those totaled 13. One included Gerald Hatcher was 2 complaints that were part of that. We didn't have any cases that we closed that were similar to court cases that were filed either by the Attorney General or by a citizen during the period. We did issue 12 reminder letters for cases that had some minor technical violations or minor errors. There were 4 cases closed that which written warning letters were issued to the respondents. And then for the other steps, the only one that I would highlight is resolved through statement of understanding. We did have one case that we found that met that criteria. The respondent did agree, completed a statement of understanding acknowledging 4 violations, 2 violations for late C4 reporting, 2 violations for late C3 reporting in accordance with the brief enforcement hearing penalty schedule in WAC 390-37-143, and they paid a $600 penalty on that. We have several other cases that may be subject to that weren't filed with us as a citizen action notice that hopefully will resolve in the future using that process. We think this is one area of those alternative responses that will be utilized by staff more in the future. We don't have any brief enforcement or brief adjudicative hearings scheduled at this time. As noted, there was no enforcement hearings, but at the April 26th commission hearing, Go Big Tri-Cities accepted a signed amended stipulation. The commission accepted that between the parties and staff, acknowledging violations of 4217A, 205, 220, 235, 240, and 245 and 320, assessed a $1,000 penalty that we have received. Be happy to answer any questions that you had.
Kurt, what can you say about the overall progress against backlogs and sort of timing of resolution of complaints as they come in?
Well, the citizen action piece has complicated that portion of it. The non-citizen action complaints, I feel that we're processing those in a more timely manner. I don't know if I could speak to any more about that or not. There are a significant number of complaints that were filed as a citizen action. Some are at the Attorney General's. Some of them have been notified that the Attorney General won't be taking action. It's not clear that the 2 years is up for those citizen action pieces, and we're struggling how to handle that. Maybe Peter could address that better if you had any thoughts on that.
Yeah, I would just add that we're in ongoing active discussions with the Attorney General's office and our own counsel as to what 2938 means to those existing 45-day letter items. And to Kurt's point, they have been the ones that are pending with the Attorney General's office, where the AG's office has not rendered a decision on as to how they're going to proceed. Our approach has been that since only the AG can take state action to foreclose a citizen's action, that we would wait to see what their decision is first. So I would expect with the impending implementation of 2938, those talks with the AG's office will quickly clarify what it all means retrospectively as well as prospectively. So what then falls into our bucket, what the AG's office does to close out the book, so to speak, and which matters that are within 2 years that citizens decide to pursue on their own in court.
So to tease it out a little bit more, I think we had talked about, so of the 427 cases in the queue showing as active, quite a number of them still show as assessment of facts, and they don't say the status is held because the Attorney General is considering. So we really can't tell from this, I think, to follow up on Commissioner Johnson's question, what forward progress is being made on those. And some of these still show as 2016. So to have it say assessment of facts at this point doesn't necessarily help us see that things are moving forward. I'm wondering, is there more you can add to that?
I think we've talked about how there's a technical issue involved there, that if we change, if we add a new category, that it wipes clean all of the existing categorization of all of those hundreds of cases. So if we said, for instance, pending with the Attorney General's office due to 45-day letter, then we have to go in and manually reassign each one of those cases to even to the status that it was. So that, with all that we have going on, we have not prioritized going in and manually changing those statuses.
So in trying to better understand which of these 400 and change, which are citizen action ones that have some barriers in moving timely because of those procedural constraints, which are totally within our wheelhouse, and how those are coming along. And because we have a firewall about enforcement matters and what can be shared with the commission, it's creates some opaqueness here in this.
Part of our discussions with the AG's office currently are getting on the same page about which those matters are. I think that we feel we've got a pretty good handle on what our 45-day letter cases that are pending over there. I'm not sure that, I think we sent them what our assessment was, what that number was, and they said, we have a different number. So what we want to do is say, okay, well, here's our 189 or whatever it is, and what's your list, and let's compare and see where we disagree and get to the bottom of those. But is that the right number, approximately?
Which one was what?
189, something like that, that we believe are our count of what are 45-day letter cases that are open.
I did a quick filter of the 429 cases, and there were at least 300 that were from filers that have filed citizen action complaints with us. Now, some of those may be just with us, but the majority of those were citizen action complaints. So maybe a half to 2/3 of the 427 were filed as a citizen action notice.
And complicating matters further, and that reminds me, thank you, Kurt, that while we encourage people to let us know when they've also filed a 45-day letter, sometimes they don't. Sometimes the Attorney General's office doesn't let us know as a matter of course, or somebody might stagger their timing in one direction or the other so that we don't know.
So is it fair to say that is part of the issue about the opaqueness that for some matters, complainants can file both as quote-unquote regular complaints and parallel file on the same issues with the same parties as a citizen action complaint? Again, this is the old paradigm, pre-effective date of 2938, and not have filed that with the PDC. so that they may direct file with the, under the old paradigm, they may direct file with the AG, and you may have a similar fact pattern here that wasn't filed as a citizen action complaint. Is that?
That's right, and every permutation thereof. So we could have, the most straightforward one is somebody sends literally the same complaint to both offices. Then there are some where, upon review, we determine that it's significantly overlapping with something that's a 45-day letter, and we might respond to a complainant and say, we believe this is in the main, in substance, covered by a 45-day letter that you also filed, for instance, and therefore we're going to defer PDC action on this. And then there are those that perhaps two different people covering the same subject matter. One files with us, one files with the AG's office, or one does both. Two same people do both. So all of those different permutations we've seen.
Commissioner Ammons.
Peter, are you aware of any of the citizens who are withdrawing or walking back their citizen action process and plan to use our process after June 6th?
I've had discussions with some people who have filed multiple complaints about what their approach is going to be going forward, and those have been helpful discussions. I don't think we've reached a final determination of exactly how that's going to play out. Understandably, they would love to have more clarity on what our process is going to be before they commit to saying they're not going to pursue matters that they have pending. Those talks continue, but no, I have not seen specifically anybody say, okay, in light of 2938, I hereby withdraw the following 15 complaints, nor am I sure what legal effect that would have. Could somebody send us such a letter and then 60 days later say, by the way, I've filed in court? Perhaps they could, and I'm not sure that's a clear legal issue.
Do you know what the Attorney General's posture is on that process of?
That's part of what we're discussing with them, and I hesitate to speak for them, but I hope to have further clarity on that I can share with you, or perhaps they will directly.
But to further exacerbate the challenge here of this dealing with the cases in the old paradigm, even if the Attorney General says we're not going to pursue these citizen action complaints, we'll defer to the PDC, the complainants still have the opportunity to go into court. So it still creates this barrier to these alternative resolutions that we would like to move forward more swiftly with. So I think, what we've been grappling with are a couple of things. How to make sure the agency is communicating clearly with the folks who have complaints in the queue, both the complainants and the respondents, as to what will be happening to those that are filed prior to June 7th, the effective date of renewal, what will be happening going forward, and whether there's any option for those who wish to refile under the new paradigm so that they can be handled more expeditiously using alternatives rather than having to stand down because the complainant might still go to court.
That's absolutely right. And one of the things that we have discussed is if we try to pursue an alternative resolution with a respondent, we want to be clear and don't have them turn around and say, hey, I thought I entered a statement of understanding with you. Now I'm being sued. What's going on? Right. So to the extent that it's an open legal question as to what those changes will be, we want to, in good faith, tell respondents, we would like to resolve this with you, but we should be aware that a legal argument could be made that even if the Attorney General's office says, no, we think we can't pursue anything, nor could a citizen, that citizen might still go into court, and we want you to be aware of that. But by the same token, you may be on a stronger footing to say, I've reached a resolution with the PDC, Your Honor, if it does go into court.
Right, but that, to me, that just is a further rationale for being more assertive with some of the, but being doing more outreach to those complainants who have filed citizen actions to see if which they might refile, because I think you have a stronger legal footing if they refile effective June 8th, when the new law's in effect, and therefore you can engage in those alternative resolutions without the specter of the complaint still going to court. Recognizing they may not wish to do that, but for some group or for some aspects of complaints where there were multiple allegations in a complaint. So I think we were hoping that maybe with putting the heads together with the AAGs, there might be an option to do that to see how many of these we can pull out of this queue and put into the new queue for more effective resolution. Without, and being clear of those complaints, they won't lose their place in line, right? So it doesn't mean if you pull out and refile, you're now case 400 instead of case 3 in the queue. That's part of the.
I would, I won't put them on the spot and ask our AAGs to opine on this right now, but I would worry that I think the legal implications would be pretty muddy if somebody had filed something under the old system and then files the same thing under the new system. I think there's a strong argument that they could move forward under the old system.
Perhaps they could, formally withdraw and stop themselves, but it is a muddy area. And for the PDC to try to give definitive answers to a lot of people who would like to know, they need to understand that during this transition period, there are unanswered legal questions, and there are independent actors, complainants, filers, and the Attorney General, for whom we can't account or say what their direction is going to be. So as hungry as a lot of people might be for clarity on this, I can see why we can't currently give it to them.
Yeah, that's exactly the issue, and I appreciate you pointing out that.
And even if you could, I would caution against giving legal advice,
Right.
obviously.
Oh,
so
sure.
even if you had all the answers, we'd have to talk about what you could say.
Sure.
Right. We have several goals. One was we'd like to expedite cases in the queue that could be resolved through alternative resolutions, were it not also the case that the respondent's going to say, that's not really something I'm going to enter into because the person complaining can go into court nonetheless. Is there a way to address those more expeditiously? And then is there a way to integrate the approach taken by the Attorney General's office in the PDC so that the multiple actors are at least aligned to the extent possible? I recognize there is no perfect solution here, and looking for strategies, I guess, a little bit out of the box to see what's possible.
I think, unfortunately, we won't have a definitive answer on these questions until long after they're relevant. I think.
Yeah, that's right.
Seriously, I mean, I could imagine a complainant going into court
Right.
and there being levels of appeals, and someday the state Supreme Court weighs in when the 45-day letter process
Right,
is
it's
a distant
long
memory.
gone. Yes, right. So it is, and as well, we're bringing on new staff for the purpose of being able to have investigations handled more quickly and have some additional capacity to do that. So they're tools, but there's not a perfect resolution. And I think the challenge both for the public and the commission is that we can't really get into the detail in any of these cases in a public meeting because of the firewall and enforcement matters. That it just makes it harder to provide the clarity and transparency we would like to do. Commissioner Downing, is there anything that you wish to note at this point?
No, I appreciate the discussion. I think it kind of circles around and sums up exactly where we are.
Yeah, I do. There is one I think we might be able to move off this list. It looks like 9059 is still on here, which was the Spokane for Honest Government case where we found a violation already.
I think that might be another piece of it. I know Kurt might not know offhand because that was a matter Bill was handling, but.
Yeah, I'll follow up on that to see if that should have been resolved or not.
Yeah, the status shows violation found by commission, and we'd assessed a $10,000 penalty with $3,000 suspended. So might be
So
down to
eight
426.
And just to address Commissioner Johnson, we would like to handle these more expeditiously, and that is our goal. So I acknowledge that they could be done faster.
And the big unknown to that point that you raised earlier is what our complaint volume might be in the new regime. It's not clear.
Yeah, and just to be clear, I wasn't trying to suggest that you guys need to be flogged to move this faster. I was just wondering sort of what it really looks like from the big picture.
Good question.
Fox Blackburn Delph, one of our compliance coordinators, brought me some numbers during this discussion. By his count, we have 291 active citizens action notices cases. So that's 291, of which 219 are awaiting AGO action, leaving 72 that are within our purview currently.
But are still not necessarily alternative resolution friendly because of the option of still going to court.
Exactly.
Okay.
And Chair, if I may, I think Peter mentioned that we are meeting with the AAG's office next week, and at that time we will be sort of comparing lists about what's outstanding with the AG's office, so we will have a better idea.
So if my math is good, we have 136 of these in the queue that are not citizen action notices that we are therefore freer to move through with alternative resolutions if appropriate.
That's right.
And, okay, I lost it.
Maybe just one final point of maybe the 50 cases I have, 29 were citizen action. I am looking at those for the timing to see if those allegations are past the 2-year mark where we could then take action. So that's probably about the best I could do at this point.
All right. So this is part of what we talked to the legislature about last session, just to sort of close this loop as to why this process needed to be reformed and how we could better serve the public. Why the agency also needed staff capacity to be able to take on more and resolve them more quickly. And so part of what we're going to talk about in our next agenda item is the hiring process and the budget process to show the forward progress on that. So recognizing we all have to be a little patient, but we know where we're trying to get, and we're eager to get there sooner rather than later. So thank you.
Thank you.
I appreciate it. So following on that discussion, let's go ahead and move into budget and hiring updates, the management team updates.
Sure. Thank you, Madam Chair. I believe you all have our expenditure tracking spreadsheet that Enterprise Services prepares for us. As usual, the big story there is the Attorney General's Office billings. I dug in a little deeper on that with the assistance of the Attorney General's Office, getting some details on what is included in those billings, and some further clarity if it's maybe a story we already knew, but it's somewhat eye-opening to see the specific numbers. So our billings from the Attorney General's Office continue to be driven largely by the campaign finance unit, and within that, largely by the Iman matter. In fact, when they sent us a breakdown of billings by matter, year to date, fiscal year to date, the Iman matter is 6 of the top 10 items on that billing, and that's because it might be broken down that their CFU, the campaign finance unit, is one line item. The Solicitor General's Office on giving appellate advice is another line item. So 6 of those 10, and it occupies spots 1, 2, and 4 through 6 of the top 10 are all billings in the Iman matter, and they range something like $150,000 to $11,000 on the low end of those top 10 items, and that's fiscal year to date, for a total of $362,000 fiscal year to date.
Peter, could I interject?
Yeah.
Could you remind the commissioners in terms of reimbursement of costs, again, under the current paradigm, which investigation and litigation costs can ultimately be reimbursed to the agency?
I wish I could give you, to a dollar amount, but as I know you know, and the commission knows, that say the Iman matter, for instance, that if the Attorney General's office were to achieve a favorable result there, it would be somewhat in the hands of the presiding judge to determine what legal fees may be reimbursed. So it could be up to the total amount. It could be something short of that, or it could be none.
But in terms of what comes back to the agency as opposed to the state?
Currently, that amount is zero.
Right.
But we would hope that perhaps with the new transparency account moving forward, some of those amounts would come back into that account and could then bridge fiscal years and biennia that this commission could recommend be appropriated to cover legal fees going forward. So hopefully that revolving account could work as a true revolving account, that over time we would see that even out.
And we got some legal fees language in this statute.
Absolutely.
Specifically.
Right.
Right, but I think the situation is the expenditure of legal fees comes out of our budget, but if legal fees are recovered, there isn't a process by which you put it back in the budget. Budget is spending authority, and if you've got revenue, you've got to deal with revenue.
Right.
So
That's
you don't
exactly
get to
right.
net it out against your budget.
That's right, unless we get it in the revolving fund, but
Right.
that's subject to wins of I shouldn't say wins, the appropriations process and other considerations.
And then we had some other issues about if the case extends beyond the biennium.
Right.
We've lost the window of opportunity.
Right, the books are closed on that biennium, and anything that's recovered that could be returned to the commission couldn't at that point.
Right. Commissioner Emmons.
Peter, are you seeing costs associated with the appointment of a special master in the Iman matter?
Yes, that is part of the cost that we're seeing there for sure.
Do you know how much?
I don't know the specific line item offhand, but I can find that out. But so as I mentioned, $362,000 we've been billed for in that matter year to date. Our total Attorney General's office billing allotment for the year is $340,000, so less than that one matter alone. And we are $303,000 in the red for Attorney General's office billings year to date. So it's pretty clear that one unit within the Attorney General's office and one case within that unit are driving all of our cost overruns.
Did the supplemental budget for PDC specifically make us whole on our previous AG overrun, or is it simply for other purposes like staff and IT?
BGSU nodding your head, did you want to?
Well, we did get money for the last biennium for our overrun. And so we started fresh, but with this, what we will need to do is put in a supplemental request for our overrun for the next session. So we've actually been working with our contact at DES, and we will be working also with OFM, and they will help us structure that request. Yeah, good question.
There's a structural problem there where the allotment that we get for legal services is based on a 3-year running average, and they've continued to go up so that average never catches up with actual billings. Maybe that will change over time after 2938, although I don't think it's a panacea to fix the problem, because there will still be referrals to the Attorney General's office that we won't necessarily be in control of what those costs are. So we could continue to see this problem. So as BG pointed out, it's sort of a fix it after the fact approach, which is not ideal, where we go hat in hand to the legislature and say, oops, it's happened again. These billings for good reasons and important cases, but no cause of ours, have exceeded our allotted authority, and it's not a great position to be in. And the legislature has a lot of priorities to balance, and won't necessarily find ours to be the most compelling. That being said, they did make the budget for this agency whole last time, and we hope to have the same strong argument to make this supplemental season.
So let's go ahead and talk about supplemental budget or for the fiscal year 2000, current fiscal year, and then going forward.
Madam Chair, do we have
Yes.
time to take a
So would you
break?
like it? Okay, we'll do a 5-minute break. We'll be off the record for a few minutes. Janet, thank you. Commissioner Downing, we're taking a brief recess.
Okay, I'm just going to hold, I think.
Yep, all right, we'll be back on the record. Thank you. Okay, we are back on the record and we're discussing management team updates, and we were just about to dive into the current fiscal year budget and hiring processes.
That's right. Thank you, Madam Chair. Switching to the better news after the Attorney General's office billing discussion. Just to put a final note on that is that other than the Attorney General's office billing, we're in black for the fiscal year, which is good news. You may have noticed you're sitting in new to us commission chairs, which are in slightly better shape, and you'll notice you no longer have the worn out wood on the. Thanks to the profligacy of our federal government, we managed to procure some surplus furniture and other items for literally pennies on the dollar, for 10% of their acquisition cost, to prepare for new hiring. So the desks, conference tables, the chairs you're sitting in, other chairs, we have been able to refresh and renew things to get ready for additional hires. And some of that is thanks to the spending authority that 2938 itself contained, that we can spend this year, but have to spend this year. So we're trying to do that in a way that's most helpful and efficient, but not lose the opportunity at the same time.
I think the chairs were $20.
Wow.
I thought they were 15. So.
Oh, 15? Okay. We're 15? Okay. Yeah.
So again, thanks to the Federal Aviation Administration for closing an office.
Yeah, I was going to ask who sat in this chair. But
And our goal at the end of the day shouldn't be to be very much in the black. It should be to
break even,
to spend every dollar we've got in a very smart and potent way.
That's exactly, and since we have money to spend by June 30, we're trying to make sure that we do that.
Yeah.
But not just say, hey, let's buy some party balloons for next year.
Yeah, absolutely. This seems like a great move.
I think the goal is to cut into our backlog and system operational challenges to the extent humanly possible.
Absolutely. And speaking of humanly possible, throwing more bodies at our issues is key, as well as technological approaches. And we have hired a new IT6, a senior information technology specialist, who has joined the team already. We have.
And excuse me, Peter, is that to replace the person who retired, or is that a different position?
It is using that position just because it was faster to do it that way for bureaucratic reasons, but it is a different position with recruited at a higher skill level and brings different skills to the table. But it technically does fill that slot.
Where does he or she come from?
From Evergreen State College. A lifetime greener, both a graduate and a longtime IT specialist there. And we have also hired a full-time receptionist that was a temp position. So we have made that permanent now. Excuse me. We are actively interviewing. We have had candidates come in for the compliance coordinator position, the compliance officer positions that we are recruiting for, filer assistance positions that we're recruiting for, another IT position. And then there will be a separate recruitment for the 2 IT project positions. Those are the ones that last for 2 years. But in the process of recruiting for both the one we have and the one we're actively recruiting, we're identifying candidates who might be appropriate for that as well, if they're willing to take the project position. We can tell them we'd love to make that be a permanent position after 2 years.
And did you mention filer assistance in there?
I did, and that is actively being recruited as well. I don't know if BG or Kim have any updates they want to add to, other than that we are actively interviewing as we speak.
Are you moving on in-house counsel?
That one, thank you for bringing that up. That one is, because it's an exempt position and it's sort of dusting off and reanimating a position we once had, is a little harder bureaucratically. It's currently with OFM to get the final approvals on it. We have gone back and forth a couple of times. Just spoke with our HR consultant yesterday, and I said, let me know what I can do if I don't want to work around you, but if I can talk to other people and help push that along, let me know. But we are not actively interviewing and recruiting for that yet, but that could literally be any day now.
And timing on the hires and utilizing that pot of money in this fiscal year and then being able to sustain that in the new budget, I assume it's on.
Yeah, oops, I'm glad you mentioned it. Yeah, absolutely. And so that's a balancing game that we definitely want to use some of this year's money for that. So we already are with the IT6 position, for instance. But balancing how we sustain it. Right. So we'll, to some degree, be just the nature of the process is such that we will be staggering some of the hiring, but also we will strategically do so for the last position or two to make sure that once we fill them and we know at exactly what salary levels, to make sure that that's all sustainable, but it is on course to be so.
So, and just as a reminder for folks, we are trying to move from a world where there have been only 2 investigators and 2 intake people and 2 filer assistance people to actually have 3 or 4.
I think this must be the largest expansion in the history of the Public Disclosure Commission.
Really, than its creation, probably.
Yes, but I wouldn't remember, just for clarity, the
I know.
How about
where we're starting from
restoration? It's more of a restoration than.
I choose to celebrate the fact that we're on the radar screen for the legislature as a significant piece of public policy, and they're putting money behind that. And so the challenges are still really large. I agree with the chair on that, but I don't know. It's just a moment for me, and having watched this organization from the very first day, and for how long it was really not adequately staffed or funded, and workarounds were with the order of the day, and so it's I feel it's a moment for celebration as well.
Thank you, and I concur with that, and we worked very hard to get here, so
yes,
we appreciate that and appreciate the commitment of the public, the stakeholders, legislators, and everyone to recognize that. Trying to balance that with the expectation that on the 8th of June, all the world's problems will be solved. So we want to keep moving forward at as expeditious a pace as possible. And
speaking of which, I wonder, Madam Chair, how we keep the OFM types and people who are perhaps expecting instant fix abreast of some of our issues, including the fact that the old paradigm and the new paradigm will not shift instantaneously overnight, and all the things we were just talking about. I don't know how we provide that backstory, but I think it's important so that they don't think we're slow in our liftoff.
I agree, and I think ongoing conversations with key legislators to let them know both the progress we're making and the challenges that we continue to face, so that they're not surprised in any direction, will be important to that effort too.
it'd be great as you bring people aboard. Feel free to just let commissioners know.
Will do.
That'd be great to show that forward progress. All right, Peter, do you have anything else on budget or hiring that you want us to do?
I guess just one final piece to mention is that we are working with DES and OFM both to expand our square footage within the building and to retrofit our existing space to fit more people in, so that we add as little as needed. But the good news there is that OFM and DES have told us that will be considered. As contradictory as this may sound, that an expansion will be considered maintenance level because of the staff changes. So the good news is it would be anticipated that's not something we would have to go back every year and say we still need that additional rent money. It would be considered the baseline of our budget going forward. So
is all that on this floor?
It is the space we're looking at. Is I don't want to get out ahead of our negotiation, our partners' negotiations with the landlord. But that is certainly a key option that we want.
And IT will still be embedded in this headquarters office?
Absolutely, yeah.
And, my major goal of being able to have the IT system not in the coat closet
Right, yes, absolutely. That's moving forward as well.
That's a technical.
I would also say that we should, by mid-June, receive the budget direction from OFM. So for your June meeting, we'll know more, that we'll be able to talk about. Okay.
When does,
I'm sorry, I was just going to say that some of the core things that we've talked, the case tracking system and the stakeholder communication system and the public meeting system and all these things that have been so out of date for so many years are all part of this discussion if we can.
Absolutely. I think, I will hope that by our next meeting here, that you will see that this has been somewhat upgraded as far as, I think I've spoken about how we hope to replace these with wireless microphones so that this room is much more flexible and can be used for other meeting spaces as well.
In a way for the public to see what's being discussed, not having the old slide screen and all that. So
right.
Just bring us up to the current century, not even.
Exactly.
I'm sorry, Commissioner.
well, not to talk dirty, but when does the new budget cycle begin for y'all in terms of planning and getting out in front of that?
It starts in earnest this summer, but we just yesterday met with our budget analyst from DES, so it's sort of an ongoing process, never ending.
So you would anticipate that being approved in August or September by the commission?
August or September.
Okay. And when's the deadline with the governor's office?
We have to have, I believe, our budget in by September.
So that just reminds me, it's a small thing. We're going to update the recurring calendar for the commission, so you'll see when things are coming to you.
I have a copy.
Great. And then what Peter's handing out is we talked about adding to the budget package the request now each year about the request of the agency to the legislature with regard to use of the dedicated fund once there is something in there. So that too would come to the commission when the budget is presented to the commission for approval. Exactly, and you'll see it what I put in there after discussing with our budget analyst yesterday is that in June of every other year for the full cycle would be when the commission would consider requesting specific appropriations, and then it's in August or September, I believe, of every year for a supplemental appropriation out of that account. Right. Okay.
I would also like to put on your radar screen earlier approval of the quote annual report so that it can be used as an information item during the long budget session. As I recall, it has information for the fiscal year, and so that if we pull that together, by December perhaps. I don't like a report. I realize that it's sort of a fiction of government to have an annual report for every agency, but to have it released as it was in May or April is clear past sessions in some years. But I would like for it to tell our story in real time as the legislators and the governor's budget are coming out.
I totally agree. Staff did have it done in December this year. We're trying to get it done even earlier. There is fiscal numbers in there. There are also election year numbers. So to a certain extent, for that piece of the report, we are tied to the election year cycle, and we want to be able to completely capture how much money we regulated in a particular election year. So that piece has to wait, but the other pieces can get started earlier.
So we had put it on the recurring calendar. It had been set for January, and part of what we discussed last year was whether we could do it in the last quarter or the prior year instead. And both have information about that it was more annual calendar, even though the technical requirements for fiscal year, if we're trying to show what happened in the election that just happened, it's going to be some annual calendar year information in there too. So
And we did make use of the commission-approved
Yes.
draft for communication
Yeah.
purposes.
But it would be nice not to have to keep doing that dance every year.
And I think there's an opportunity to, as we discussed about telling the story of how things are going along the way, that we develop charts and figures that are useful starting immediately. And to the extent we're able to keep those updated regularly, it's a non-annual report of sorts where we can share a scorecard of sorts with legislators and others without it being the official annual report that needs to go through the hoops of the governor's office and all of that.
We don't need to spend a lot more time on this, but I'm not entirely sure why, when we say our annual report is done, somebody else has to say, yes, it is done. I mean, why is that a legal requirement, or is it just something that we go along with because the governor's office asked us to?
Kim, do you know the answer to that?
We asked that question, and there was no legal requirement that was cited. It was just a matter of past practice, and that is the procedure that small agencies go through.
Okay, well, it thwarts half of the purpose of it, so we might reopen that conversation at some point.
Well, we also talked about the difference between an independent agency and a small agency
Right.
that's part of the governor's cabinet.
Right.
So this is the former, not the latter.
Right.
So. Okay, so speaking of communications, maybe, should we want to do the rules update first, and then we'll do communications, or what's your druthers?
Sure.
Go ahead.
Sure. So I apologize. I definitely misunderstood what the commission was looking for as far as, I think I'm just in rule drafting mode. So what I sent you were sort of cryptic, just the whack and a brief description. What I will do is go ahead and capture a bit more of the discussion around some of the issues that the commission spoke of, and create a Word document, a bulleted Word document. And then Kim's going to talk a little bit about, when she goes over the communication for those, what our plan is of how people can comment on those. And so she'll be talking about that. I guess that's kind of what I have to say about the rules.
So just for clarity in the schedule, so the matters that we left as, or ideas we left as pending for potential inclusion in the permanent rule, next couple of days we'll just get a Word document that's got the language in there. And that will provide guidance to Kim also and team about what we might want particular communication to stakeholders about. Please give us your input on this and this as you look, so they're not having to read the whole rule. And also as a check for the commissioners, if there was something they thought was put on the table for permanent rule that doesn't show up on that list, it's a chance to just pick that up.
Sure.
And then can you remind us, Fiji, the draft of the permanent rule? So we've got on the schedule we went over at the last meeting.
Yeah, it's about June 19th. We should have the draft of the permanent rule to the commission to take a look at.
Okay.
And then the sort of the real stakeholder process begins. Well, actually, it begins with the emergency rule. But I think, Kim, you're going to talk a little bit more about that. So I believe it's they're around June 19th.
Okay. And so just into following up on Commissioner Hammond's point, so there's sort of two things in that. There were some things that didn't fit under the umbrella of this is an emergency rule appropriate. This is an improvement to WAC we'd like to make, but we can't really say this is because of this emergency. So you wanted to put it in the permanent rule. And there were a few others where we said, we want to get more stakeholder input on this. It doesn't have to be done for the emergency rule.
Right.
Let's put this for consideration in the permanent. So that's what will come back to us to make sure that universe was covered as you had hoped. And then and you'll be using that for drafting for the next version that comes to us in around the 17th of June. Yeah. Okay, great. All right. So Kim, do you want to?
Sure. So just a quick update, customer service update before I launch into the timeline that I gave you, the updated timeline. We are seeing an expected increase in requests for assistance as campaign season gets underway. We're up about 120 requests over in April, and we continue to see increasing volumes as people try to file their initial forms and figure out electronic filing. We have had staff's done really well at keeping on top of those with resolution times. Our average resolution time across the team is 16 hours. So within a day, on average, we're getting to those. On F1s and T1s, we haven't quite yet turned the F1s over to compliance. We did do yet another reminder, overdue reminder to filers. We are, I'm happy to say, at 90% compliance rate on F1s now. So we have about 500 that we think are outstanding. And on the T1s, it's even better. We have about a 95% compliance rate there. There's only 19 outstanding there.
Great.
So.
Can we be able to tell from the 500, is a significant percentage of those the small school districts, or is this the whole?
They're all over the board. I've been calling state agencies. I've been calling, there's some little ones. There's some big jurisdiction. I mean, it's just all over the board. Yeah.
And then on the questions that staff are getting asked from new candidates, is that showing us any sort of new issues or things to emphasize for communications and training that people don't understand, or it's the same kind of stuff?
It's kind of the same what we're used to. Right now, they're just trying to figure out what they need to fill out, how they can fill it out, and what goes in what field.
So do they just cold call or send in an email or something, as opposed to finding information on the website that would answer their questions already?
So primarily when I talk about the numbers, I'm talking about email requests, written requests. And as much as possible, we do direct them, we provide the information, and then also provide them a link about where it is available on the website, or they can get more information about a particular thing they're asking about. So we do, sometimes they can't find it, sometimes they haven't even really looked. They're just, emailing us straight off and saying, help me with this. So
could you tell us a little bit filing week also?
Okay, yes. Actually, we're going to talk a little bit under process improvement about that, our declaration process. So it was filing week last week, and we are in the midst of that. That's a pretty big task for both IT and customer service every year. And James will give you a little bit of information about that here shortly. But yes, we're in the process. That's one of our big tasks of the year. Turning to the timeline, what I did is took the rules timeline that you had received, and rather than create something new, I incorporated the stakeholder and outreach work into it so that we could work from a common document. Couple of guiding principles in putting this together is that we wanted as much as possible for this to be a living document, and as we hear from stakeholders and from the public and from you all, that this will continue to be refined. For example, our talks with the AG and determining what's going to happen to old complaints versus new complaints, that eventually, once we get that sorted out, will be incorporated in this so that we can do some outreach to the complaints that are now on file with us pre-2938. We also are, as much as possible, trying to create outreach materials that can do double duty. So when we're updating guidance, that's also, we're going to steal some of that to also send out to filers. So in a very simplified format. So as much as possible, we're trying to not create single-use documents and make the best use of our time. Right now, because we do have, as I mentioned, a lot of people who are running for office, maybe for the first time, who are wondering what rules apply to them, that has been primarily our focus, is trying to take the emergency rules and translate them into guidance that filers can use come June 7th. So we've had a work group meeting to refine what we have available and identify what additional pieces of guidance we need. And that will help inform the rolling releases that I called out here that start next week for people. And what we envision is an email that says, here's a broad, really high-level overview of what's changed, and here's where you can find out more. And not just the rules, but plain language. The rules that you have passed in the last 2 emergency meetings are posted on the website in a more readable way than they were sent to OTS, since we tried to pull out what had changed rather than including the whole kit and caboodle. And there is a dedicated web page that's linked from the homepage that's available to folks now, so that if they want to go start figuring it out for themselves, that resource is available. And we will try to, as we're rolling out guidance and additional outreach over the next 2 weeks, we have a very short time frame to get this out. We will continue to boil that down for folks and really take it out of rule language and explain to them what it means.
What is your method of distribution of that? I really like the idea of a primer on what's changed. It strikes me that a lot of people would need that, from reporters to filers to, something on our website that's really clearly marked out. This, read this.
Right. So, yeah. In the email that we will send out, hopefully today, it will call out kind of a bulleted list of what's changed, and very high level. There are new thresholds for reporting debt. There are new thresholds for reporting pledges. There's a new campaign inspection process. Just kind of so that they can say, oh, that affects me, and then go find more information. We're trying to, you always walk it's always a balancing act between giving a lot of information and too much, or giving enough information. So we're trying to, in the email correspondence, give them highlights and then give them opportunities to find out more. And what our initial plan is to broadcast the initial email widely, and then provide people the method by which they can opt in to future publications. I don't want to be just spamming everyone constantly. So we want them to if they're interested, to opt in. And we do have a subscribe page. It's already set up with a channel for 2938 News for those interested parties. And so that's what we'll use for the rolling piece of the guidance.
Would you send the commissioners a copy of your email?
Sure.
Thank you.
And then
You can also opt in on the website.
yes, I was just going to say the opt-in and the stakeholder list on the website is a great example of sort of antiquated systems and how labor-intensive things are. And so when I say things like, can't we just do these categories like this? I learned that with our system, there's a lot of labor in doing some of those basic things that.
Do we have any filers? I'm thinking maybe lobbyists or people for whom the world isn't changing.
Right. I would not include lobbyists in the initial mailing, just because I don't have anything to tell them. So probably the universe is C1 filers for this year, and people who have already told us that they're interested in any kind of stakeholder work we're doing.
Do you have a listserv for treasurers started?
We have, it's called Information for Candidates and Committees. So that's a listserv that already exists. And when people go to our subscribe page, it's been quite slimmed down since you and I talked. There's about 5 or 6 options, and Information for Campaigns and Committees is one of them.
So one of the things that we talked about is, can we make this sign up more user-friendly, if you will, and stratified? So it's like, send me anything that's interested treasurers, or send me your agendas, or send me your rule. So whatever it is they're interested in, but it's sort of, it's a little hinky. Is that the right?
It's the technical term.
Well, actually, you should probably take another look at it.
Good.
Yeah.
Great. So stuff like that, so that it's people who don't want everything but have a particular area of interest. in
Thank
keeping up to
you.
date.
I'm really pleased at your plan. As an old communicator myself, I just think we're at that moment where we need to speak with a lot of people about the changes that have taken place, and for some it'll be kind of big.
Definitely. And as we get that guidance piece out of, past us, or the bulk of it, we will move into more stakeholder work about the permanent rules. We're setting up systems in Freshdesk so that we can monitor comments that come into PDC at pdc.wa.gov and post those on the website, and allow people to then comment on the comments. So we are looking at those pieces as well.
Would it help, or should we put something on the homepage to get people directly to this topic? I'm just kind of looking at.
It was there this morning. Do you see it in the lower left-hand corner? Or have we?
Well, I see featured content. But it says Commission adopts emergency rules too, and then goes ...
Right. That is right now our landing page.
Yeah.
There will be more, but that is right now the landing page from which we'll then direct people elsewhere.
Okay. So maybe just something there that says
Highlight
new
it.
law or 290 or something that. Okay.
Is there any way to get into the landing page to have it a higher visibility up on top, a banner headline, if you will?
Not correct. That's something we were talking about. Not currently. It's something we were talking about this morning.
James, go ahead and have a seat.
I'll just stay here.
Yes.
Come on.
I think that's a really great idea, and I think the same place where you would say our power is out, or we're closed today because of snow or whatever. You need a landing page where people can know they're not going to get instant help, et cetera.
That was the context, actually. The power's out, those kinds of things was the context of this morning's conversation.
Not to steal your thunder, but James might have an announcement to make that he wanted to.
Let me ask you to introduce yourself.
Yes, I am James Guthulm, Chief Information Officer, and I've also brought someone with me this morning. Dave Metzler joined the PDC just this Monday, and Dave comes to us with 20 plus years of experience at the Evergreen State College as lead developer, joins us as lead developer and technical architect. And Dave has jumped in feet first and was an integral part of the process improvement that I'm going to talk about as well. And so Dave, and then we have Chair Levinson, Commissioner Johnson, Commissioner Emmons, and Commissioner Downing is joining us on the phone today, and we have one vacancy right now. And if you have any questions for Dave, or maybe is there anything you want to add?
I guess I can't add too much. I'm obviously excited to be here. I love the mission of the PDC, and there's lots of meeting technical challenges for me to sink my teeth into, so it's all good.
We tried to keep our systems pretty out of date so that when you got here,
Only improve.
James, what are the advantages of adding a fighting GUI duck to the team?
Well, we already have one fighting GUI duck on the team. So Dave's an alum.
Yeah.
I'm an alum. I'm a past employee. Dave's a past employee. An alum. Father of an alum.
Okay.
So we're pretty well infiltrated with GUI ducks now.
I knew you must have some affiliation because you were careful to say the Evergreen College.
Yeah.
All right, so let's dig in. What else? Anything else on communications?
No, unless there are any questions.
Okay. So could you just clarify for us, as stakeholder comment comes in, remind us sort of how that gets compiled and brought back to the commission and incorporated into the process?
So as I said, we are creating a system in Freshdesk to track those and segregate them. And then I think there was a spot on the existing calendar before I incorporated the outreach to bring those comments back.
Right. So in a public meeting, we'll be able to have that discussion, and so stakeholders can see that their input was heard and how it is getting addressed.
Right, and that will be at your public meeting, and that will also be an opportunity for members of the public to come and speak directly if they want to do that.
Great,
thank you.
Yeah. IT.
All right. So probably the most exciting thing to report today, just left the room, but yeah, getting the one position filled is already making a difference in how we're doing things. I'm also really excited to report that we are very close to making an announcement in filling the second of the permanent IT positions that we had open. And at that point, we'll have the core team, and then we'll make a decision about the 2 project positions and where we need to fill in to basically complete the picture. So things are looking good on the hiring front. Just a really kind of brief update on work that's been going on. We're continuing on some of the kind of smaller, make things feel better for the regulated community projects. And the one that we're working on right now is we always have a lot of pain when people are installing the Orca software when we do an update. And one of the reasons is because you get all the antivirus, are you sure you want to install this software kinds of warnings. And so we just recently purchased what's called an extended validation code signing certificate that both Microsoft Windows and the Apple operating system consider the software golden, if you will, and don't present all those warnings and say this is from an organization that has been thoroughly vetted and signed with certificate. So this is really good news. We'll have the certificate in 4 or 5 days and start doing some testing with that. And we're expecting to roll out a new version of Orca that will also have some updated jurisdictional information as well as some language changes related to 2938. And that will be in the 1st or 2nd week of June. So we're getting really close to doing that. And then lots of other smaller things going on. I've mentioned, of course, the work about getting out of the noisy room over here and over into the state data center, and that's ongoing, as well as the authentication environment that we're moving to. So there's a lot of moving pieces right now. And planning is probably the biggest one. I mentioned last month that the management team, now that we had gone through sort of figuring out the rules to implement the legislation and the business process that goes along with that and how people are going to do things, have started working on, well, what are the actual projects? But not only that we have such a short time frame and such a huge amount of stuff to do, how do we figure out how to deliver the most valuable pieces of those to the public in time so they actually make a difference? And we've already heard that people want to know how to file a dissolution. And when the date comes that they can file a dissolution, we need to have something in place to make that happen. And we also know that if we tried to say, let's have the Cadillac of filing your dissolutions, we won't have people able to understand if we've had an outage and whether or not they get, if you want to call it a grace period on the filing date because the outage was so long. We won't do any of that, and we won't do anything that will help us track tickets and time frames related to citizen action. So the strategy is to figure out what is the piece of this that we can do that's provides the most customer value, and what are the core things that we absolutely have to have happen very early on, and not say, by the way, for the next 2 years, we're not going to make any progress on all of those customer-facing and public-facing things that we already know we need to do, like having a new F1 filing system and a C1 filing system and a replacement for Orca. And that's the work that we're doing now. And so the management team has figured out kind of a basic strategy. Today, the technical team actually broke down that strategy to figure out and start doing some estimating around how can we approach these and what will it take. Now the task is to go back to the management team next week with some rough estimates about this core piece is 6 weeks and this core piece is 8 weeks, and present those back so that we can then prioritize those to say, absolutely this first and this right after it. And here's the secondary path that we're going down to make sure that we get the F1 done, for example. So that is all coming next week. So I think we're going to have some exciting news to share at the next commission meeting about prioritization. And on the scorecard, you'll see that probably everything will change. We're pretty confident that we're going to start doing 2 kind of major teams. We've always said we just don't have the capacity to do more than 1 stream of major work at a time because, of course, there's all the little side things that go on at the same time that have to happen. We're feeling pretty comfortable that when we bring the 2 project positions on, that there will be 2 streams of major work and still be able to do those maintenance items at the same time. So it's exciting times, despite the fact that there's an enormous amount of work to do.
So, James, if you do interim improvements, knowing for exactly the purpose you just mentioned, was so they can get up and going, I'm wondering if there's a utility in noting that on, like if you're putting up a form or an approach that you know isn't the gold standard that you want, if you have more time later, instead of having customers go, this is the new thing, can we make it clear this is I don't know if temporary is the right word, but this is an interim?
Absolutely, and it's part of the conversation that we were having yesterday about how to stage these out and the risk of doing thing A just to the point of making sure that we can implement the law and somebody looking at that and going, really? This is it? Right. And figuring out how you communicate that outward so that people can see what our plans are. And I know from talking to members of the public, people are very interested in what our long-term plans are and what are the projects that we're working on. And that's part of that communication strategy, particularly around 2938 and the related projects that we will have to pay very close attention to make sure that doesn't happen. So people know that we have a grander vision of implementing the law than just what we need to do to keep things moving.
And a related point is to make sure those interim pieces are not just things that some inevitably will be, but are just scrapped when you get the better version. Right. It's that it's something that we can build on.
Right. Yeah, and I was just thinking if the way to say this is an interim and will be built out later,
right? Kind
of things.
Features that we anticipate.
So we're both meeting expectations of speed and quality as we go. Commissioner.
James, I was 2 questions. First, do you have an ETA on the Commission's desire to have F1s online? And second question is, what is your thoughts about what you're going to do with those 2-year positions in IT? Are they going to? You talked about maybe 2 streams, but kind of your dream of what you can do with those positions.
I might redirect me if I read the question wrong. The 2 positions are software developer positions, and they will be devoted to the 2 streams of projects. Okay. Yeah, and they're lower level positions, so they will be implementers of direction and strategy.
What would you achieve that you wouldn't have been able to if that piece hadn't been approved?
Without those positions, and particularly with the enormous amount of additional work related to implementing the legislation, we certainly would not get a new F1 and a new L5. I don't think that we would get to the point of being able to get the specifications, gap analysis related to Orca done. either, because the reality is that, yeah, we're doing these smaller solutions to get the legislation implemented, but we can't just stop there. Because even if we do a good job about saying, and we need to do more on this, if we said, and we need to do more on this, and it's 3 years later, by the way, I don't think that would buy us a whole lot of goodwill, and quite frankly, wouldn't be doing proper service to the public either. So that's really what we gain out of it, is we gain the ability to stay on the path that we had laid out to accelerate that and take on the extra work related to implementing the legislation.
And F1.
Oh yeah, thank you. So for the F1s, the technical challenge is 2% of the rest of the work, and so I will let Kim speak to the communications plan.
And James and I have been discussing this, and we do need to get word out to filers, and when we do get word out to filers, we want to be able to, at that point, answer the concerns that have been raised through the years about potential identity theft. We don't think this increases the risk of identity theft. These are already public documents, and the information that's being asked of them is not, in our view, the very sensitive information that might cause alarm. But in the end, it is a public document. So we have been doing some work behind the scenes to try to get some of those questions answered from an authoritative source. And then we feel like we can go out to the filers and then quickly out to the public.
And Kim doesn't even know where we are with this, so this will be news to Kim too. We had talked about what other resources do we have, and so I reached out to the state privacy officer, who has then put me in contact with one of the individuals in the privacy office, and we're going to set up a meeting just to have a discussion with them and understand, are there any pitfalls, things that we're not necessarily thinking about, just to really help understand our approach at the end of the day. Of course, we know that these are public documents and people are already potentially asking for thousands or tens of thousands of them, but it's still important for us to make sure that we've vetted what we're doing as thoroughly as we can as well.
Commissioner Downing, do you have any questions?
No, I'm here. Thank you very much.
Great, thank you. And anything else from the team?
Process, do you want to hear the
process spotlight?
Very quick process spotlight, but really exciting too, I think. I've come before the commission a few times in the past and talked about the work that we've done to utilize data from the Secretary of State's office and other data that we have to try to automate lots of these manual processes that we have. And declarations is one of those where way back when, 3 years ago,
seemed like a long time ago.
We would get a spreadsheet from the Secretary of State's office and request one from King County and request one from Yakima County, and a human being would just start typing stuff in. And a few years ago, we started saying, well, we've got all this data, why don't we start trying to do something with it in an automated fashion? And the answer was, well, they do everything different, and they don't call a fire commissioner or anything even remotely close to what we call it, and all the counties call it something different, and on down the list. And we started doing all the hard work about saying, how do we map jurisdictions used across the state, all controlled by the counties, into our space, our sense of what is a fire commissioner, and then what jurisdictions it's associated with, and had started building out the data sets necessary to do that. And then last year, the thing that we did to add on to that is we actually preserved the link between a filer ID at the PDC and the state candidate and voter registration data that we have access to, so that when we see a candidate coming in, their candidate ID may change from election to election, but their voter ID doesn't. And so we can actually see they declared and they have a voter ID, and from that voter ID, we know exactly the PDC person that you are. It'll take us 6 years to get everybody that's an incumbent, of course, But between last year, where we had a very large number of local candidates, and now where we have a large number of state candidates, we're building a substantial set of that data up. So fortunately, we had Dave here. Unfortunately for Dave, that was actually the first thing that was dropped in his lap when he walked in the door. Bruce Wendler had done a really great job of starting to pull all those pieces together, but not the automation necessary to coalesce it all. So Kim, knowing that Bruce was going to be gone and he had done all this declaration stuff in still a pretty manual way, was brilliant to say, we need a concrete plan, we need regular meetings, and everybody gets together and we know the responsibilities and a checklist. And so we did the whole declarations process this time, and we're still doing it, but in this incredibly organized way where we all knew what we were going to do, we knew the steps, we knew the points where we should say, let's take it to the next step in terms of how we're processing the data. And we get together every single day and say, whose task is it, where are you, what's the next step? And the wonderful thing is, of course, Dave started Monday, and Monday spent most of the day filling out paperwork. And by the end of the day, Wednesday, had the process of delivering the data fully processed, converted into our jurisdiction space, names mapped to the legal voter registration names of the candidates at the end of the day, Wednesday, and just had to ask me, so do we make a spreadsheet and hand it to them? And we did that this morning, and it was handed over to Kim's team, and did all the programming to make that happen rather than doing it manually. So. It's been wonderful. I mean, not only just to see the technical work happen, but really that organized process take over about these are the things we do, we meet, we talk about them, we make sure everybody's on track, and we hit the dates that we intended to hit. And so we delivered that piece of it today rather than Monday, or Tuesday actually, which was the planned date.
That's true. Thank you.
You're welcome. Anything you want to add about the process improvement?
No, I'll just give a lot of credit to Dave for just coming in and jumping off into the deep end and really figuring us out. And he's been very enthusiastic about it all. So yeah, it's a big improvement. Knock on wood. Still got a little bit to go.
That's great, Vince. Thank you.
I have a question sort of at large for the management team, and that comes from the update on the outstanding penalties. See if anyone has any comment or explanation about the fact that an awful lot of penalties have been out there for what's closing in on 2 years to collection, and at least a number of them are for people who are sitting in publicly elected offices. I will pick as a random example a fire commissioner in King County. Is there anything, I mean, it's hard to imagine why a matter that was ordered, approaching 3 years ago, went to collection approaching 2 years ago on a public official remains unpaid. Any explanation or observation or concurrence on that?
This is Jana, the administrative officer. I do the penalties and the collections. Are you talking about the items that have gone to Alliance One?
Yeah.
Yeah. Once they go through DES, that's our process here, the 30, 60, 90 days, and sometimes we even negotiate to extend it out if the person contacts us. Once they go to Alliance One, there's not a process in place for that we go after them any longer.
Yeah.
I have seen maybe, and I've been here since 2010, maybe 10 actual collections, successful collections from Alliance One at that point.
Wow.
Yeah.
I mean, if I were in the voting pool of some of these districts, to find out that one of my elected officials had violated the law, and B, 3 years later still hasn't paid for that violation.
Commissioner, I will say this, that even when they don't pay that violation, if they're still in office and they come to file or that does come back into effect, that you have an outstanding balance, so it does come back into effect.
Wow.
And I will add that Jana is really good about updating the case status page so that when there's unpaid fines, that's reflected there. Yeah. Or suspended penalties that then are unsuspended because of non-payment.
Right, sure.
So really great point. We've talked about a few different approaches in the past. So one is making sure it's on the case tracking status, so it's publicly available. Another is whether we wanted to do more communication externally about that. Another is whether we have on our future, if we had capacity list, to have a discussion with the state about integrating collections. So for folks who are untimely with us, you shouldn't be able to renew your business license if you have an outstanding fine or if you, right? So for small agencies in particular, there's just not the capacity, and it's not a good use of public resource to go after a $250 fine and spend. But to be looking at them in an integrated way across Department of Licensing, Department of Revenue, agency, would seem to make sense for the state to do. And then we've talked also about ensuring, and this will be easier now that the so-called 45-day letter process doesn't have independent action by the AG, of making sure that anybody who's got an outstanding fine, that there's clarity about whether it's a proposed stipulation, settlement, any other complaint in the queue, that has to be integrated. But the accountability isn't what it should be.
And Commissioner Johnson, the ones that you see in the past, and you said they are a couple of years past, if you look at the ones starting from last year forward, you can see a consistent, they've been paid. They've been paid. So you can see that's when the date where we implemented the new process and started using DES, you can see a very high rate of payment kicking in. The old ones, were not part of the process.
Yeah.
There was no way to track them until we got this into place, so, yeah.
It's a system improvement, but it was a system improvement, but going forward.
Yeah.
Okay, thank you. Thank you. All right, we are past our time, so I'm going to now move us into executive session. Executive session will be for discussion of matters allowed pursuant to RCW 423110, including but not limited to discussion of enforcement matters and pending and potential litigation with legal counsel. We do not plan to conduct any business following the executive session, so the executive session is scheduled to end at 12:30 unless extended by an announcement. And at the conclusion of the executive session, the commission meeting will be adjourned with no further public action. At 12:30, there'll be single officer hearings with regard to additional modification requests. Thank you all very much. Good meeting. Thank you, Commissioner Downing. Safe travels.
All right, thank you very much. Bye.
And we'll be off the record. Thank you, everybody.